Let's talk about legality of contracts. If someone promises to sell you an ounce of cocaine for whatever cocaine goes for and then breached that promise, how likely are you to get a remedy in court? It doesn't take much common sense to see that illegal contracts are unenforceable. The cocaine example is simply common sense. Contracts that are contrary to statute, i.e., the laws prohibiting illegal drug sales in this example, aren't enforceable even if there's an offer, acceptance, consideration, all the rest of it. The more difficult legality issues are those contracts that may not violate statutes but that are contrary to what's called public policy. There is a societal goal we're trying to create or at least encourage when we enforce some agreements and not others. There are times when courts decline to enforce contracts, even though there's no statute barring their enforcement. If these contracts violate public policy, in other words, they're not enforced because they do not advance our societal goals. Such contracts are treated as if they were illegal, even if technically there is no violation of a statute. I can give you one example from a case I worked on. It was a large and still existing heating, ventilation, and air conditioning HVAC company that decided to enter the residential market. They had previously manufactured only for large commercial businesses, but they wanted to start doing residential sales. They entered into a joint venture with a lender, and the way they were going to market these air conditioning systems, which were incidentally very expensive, was through door-to-door sales. As part of the lending portion of the agreement, they were going to sell these along with the loans that would finance the sale. That loan would be secured by the value of the homeowner's house. A secured loan means that if you don't make the payment, the lender can come and seize the property without any particular order against you. So, for example, many of you have a secured loan if you borrowed money to buy a car and you haven't yet paid it off. If you stop paying, the security holder can come and seize the car. So a car loan is an example of a secured loan. An unsecured loan would be if you don't pay your MasterCard bill, let's say. Are the MasterCard police going to come to your closet and grab that shirt you bought with the MasterCard? No, you certainly owe the debt, but it's not a secured loan. So these particular air conditioning systems, in our example, were being sold with a secured loan, secured by the value of the house. Now, would you enter such an agreement? Would you buy a very expensive air conditioner, secured by the value of your house, so that if you stopped making payments, the lender would come and take your house? I hope not. Well, who would? Think about it. Door-to-door sales, and this happened in Los Angeles County. Who would you try to target if you were trying to get people who would agree to this? Think of the areas in town. You would target people who are less likely to understand English, people who are less likely to be familiar with American contracts, and those with lower levels of education, although they still have to own their homes. So what part of town would you choose? Well, these companies chose East Los Angeles and South Los Angeles. And what time of year would you choose to sell this product? Well, that's what they did do. They went door to door in the summer in South LA and East LA to sell these products. It went to court because there was a class action for a lot of homeowners who lost their homes. What did the court do? Well, is there anything illegal about selling air conditioners? No. Is there anything illegal about secured loans? No. But are you deliberately taking advantage of people in a way that really exploits their lack of understanding and sophistication? Of course you are. So the court in those cases simply said that these contracts are unenforceable. We're going to reform them so that they are fair. Certainly the lender also has the right to get their money back. However, the way these contracts were written was so grossly unfair to the borrower that we won't enforce them. That's an example of courts stepping in, treating a contract as if it were illegal, although in fact it wasn't. What the courts did in those cases was to say that the fair result would be to allow the lenders to come and either remove these very expensive air conditioning systems, but not take ownership of the house. And that's what the courts did. Now, there are a couple kinds of clauses that sometimes trigger courts' increased interest. They're not illegal, but courts certainly see red flags being raised, and they look carefully at some of these provisions. The first such provision would be covenants not to compete. A covenant is a promise, and these are usually contained in larger agreements. This would be just one provision of a larger contract. A covenant not to compete is an agreement where the parties agree not to compete with each other commercially in business. Such agreements may be barred by statute, for example, antitrust laws. But if they are not, they are subject to being invalidated nevertheless on the grounds of illegality, on the basis of public policy. The idea is that in a market society, all of us benefit from competition. Merchants are forced to compete by improving products or lowering costs so that we all benefit. This desirable societal goal is thwarted when parties agree that they won't compete. For example, when companies carve up territories or agree on minimal prices that they'll charge. This becomes a very complex area of law pretty quickly. But for our purposes, please realize that any contracts that limit competition could be viewed by courts as violating public policy and therefore unenforceable on the grounds of legality. The second kind of clause that a court might look at very carefully are exculpatory clauses. These are agreements where a party has agreed not to sue another party, even if there are grounds to do so. Well, now, why would anyone sign such agreements? Well, half the time people don't realize that they have, and that's part of the problem. Such agreements are often hidden in larger contracts that are about other topics. Did you really look at that lift ticket that you bought at the ski lodge? There was likely an exculpatory clause in it. For this reason, courts are pretty skeptical about them and may not enforce them. There's no hard and fast guideline here, but simply be aware that courts may find such agreements to violate public policy and be unenforceable, particularly if the parties subject to the agreement had little real choice and little likelihood of understanding that limitation. The third clause that often raises a court's concern is agreements to binding arbitration. We spoke about arbitration earlier. It's when you agree to sort of an informal trial outside of the court system, typically. There's binding and non-binding arbitration. Non-binding arbitration would mean that if the parties aren't happy with the arbitrator's award, they could still go to court. Binding arbitration is the opposite. The arbitrator's decision is final. You're stuck. Do you ever want to agree to binding arbitration, or do you want to put such a provision in a contract that you give a client, for example? Maybe. It's certainly cheaper and quicker, and your legal fees would be lower. However, you're giving up legal rights, and you need to think carefully about that. So courts are concerned when parties are seen as having greater power and imposing that provision on another. For example, the hospital, when you were rolled in on a gurney, having parties sign arbitration clauses, possibly without fully understanding that they're giving up their rights, would cause the court to look carefully at whether such a clause should be enforced. Again, these are not per se illegal, but a court might view them as violating public policy and refuse to enforce them. This topic is much broader than we have time for, but this should give you an overview of the sorts of things courts are likely to look at.